and we can date back hundreds of years. Importing has always been a high-risk, high-reward obligation.
Welcome to Simply Trade, brought to you by Global Training Center. My name is Lalo, and together with my co-host Andy, we have well over 60 years of combined trade, logistics, and supply chain experience. Along the way, we have seen and witnessed different challenges in trade compliance. We decided to put the show together and call on our friends and colleagues in the business to hang out with us and share their knowledge in all things trade. Thank you for spending some time with us. Enjoy the show. Hey Andy, well, so we're back. We're going to pick up just where we left off. We're going to continue with this talk that Jennifer was talking about on best practices on ADD CVD. So,
well, I tell you what, this is one of those that, folks, you're probably going to need to look and go back and listen to this a couple of times. There's a lot of detail here. This is a deep topic. And it's one of those that you're really going to need to spend a little bit of energy thinking through what is being said so that you can then take actions as appropriate if you're in upper management or if you're in the compliance arena to say, what are the questions you need to be asking of your staff to ensure that you're covering the T's and or, crossing the T's and dotting the I's for ADE and CVD.
Right. And what we got to remember is that we're looking at it in the perspective of two attorneys who have defended or helped people who have gotten in, or companies who've gotten in trouble, and so we're looking at their perspective and what they've seen and how they're helping. So let's listen in.
One of the things that is you're hitting on, the Department of Commerce, the way they classify commodities is nowhere close to even being close to result.
Because they don't classify commodities.
It's the weirdest. It's where it's off of descriptions. And it is a convoluted mess. Is that pretty valid?
And the bigger problem is that Commerce also uses what I call revealed light when it comes to scope. In other words, if we're dealing with a dumping order that's 5 years old, and Commerce says, oh, you know what? This product's subject to scope after 5 years, and everyone thought it wasn't. It isn't subject to scope starting from that date. It's revealed light. We've revealed the true nature of the product, and it goes back to day one. And anything that's unliquidated gets dragged in, even if there was no issue had ever been raised about the product. And it is Commerce uses what I call revealed light when it comes to scope.
It's so unrealistic.
The other aspect for this, Andy, that I think is really important, and that David and I have both seen, is you may have a case that takes 17 years for that particular entry to liquidate. So we've seen some, and granted, that's not the generic tone. Typically, liquidation is faster than that. But imagine Customs is coming back to you however many years later when Commerce finally gives liquidation instructions to Customs for that particular entry. You may be talking about something that happened almost 20 years ago.
Right.
5 is completely realistic. I had a case where I challenged Commerce Department on a determination, and I won at the CIT, and it came back, and then the other side appealed to the Court of Appeals to the Federal Circuit. I won. It went back to the CIT. It went back to the CAFC. Went back to the CIT. It went back to Commerce, at which point Commerce said we don't have to do anything because the petitioner decided not to keep the case alive. It took 5 years to litigate, and the case died. But it was 5 years of frustration for the importers, even though ultimately they didn't pay $1, because it was 5 years of uncertainty and litigation costs.
Well,
and they didn't get their attorney's fees
right.
back.
Well, but here's the thing, though, is that in looking at it, I have seen, generally speaking, that when there is, in the past, it's gotten better of most recent in the last few years in speeding up the actual investigation. But even though there's supposed timelines on this, there was reports of, taking forever for a case to finally have the investigation end and a determination made and whatnot. And as you just said, every one of these the record retention. You just keep it going. It goes out there forever. Well, companies come and go. In addition to that, is you've closed out your books, and you don't even know how to allocate anything. Should you be allocating something year over year and carrying it over? So all of that to say, let's change gears here a little bit. Is that with all this, is that there's definitely, this is after the fact, a case gets filed, you're tied up in the courts, to customs, to commerce, which Department of Commerce is not easy to deal with at all. Again, what would you recommend then for somebody to try and say, I've got to show due diligence here, and even that doesn't sound like it gives you anything, but what should they be doing in preparation for importing a commodity?
Let me address this. What I think they have to do is they simply have to carefully know what the risks are. They have to make a cost-benefit analysis. They have to make a decision as to whether they're willing to undertake those risks. And if they're not willing to undertake those risks, they need to rethink their business model. And for example, if I am bringing in a commodity, and there are commodities out there that has a 8% profit margin, I am going to seriously reconsider whether I need to be in that industry as an importer. If, on the other hand, my profit margin, because dumping will do this, there are products out there with 200 or 300% profit margins because the dumping has so raised the U.S. price, then it's a worthwhile risk if you know your risks, you know your factors, you've listened to Jen, you've set up every possible protection you can, including other corporations. You can, and you trust your supplier, you can import with a high degree of certainty that you're going to be okay, and you're going to find a way to get that money and transfer it out of the company to somewhere where it's safe, and you're fine. But if I'm in an industry that has a 3 to 5% profit margin, and I hear this all the time from importers, I can't afford the dumping duties because I resell at a 10% markup, my answer to them is, you're probably in the wrong industry.
A couple of tips. One is, we hear a lot, well, I'm just going to make my supplier send it to me DDP. That's another thought process, is who bears the liability? And then think about that at the beginning. So as a lawyer, what do we always ask? Show me your contract. And then we get, you think I have a contract? I have a purchase order. That's a contract. And a commercial invoice. Good enough. Like, what do you think? I negotiated a contract? I bought this on Alibaba. Mm-hmm. My favorite, right? What's your contract on Alibaba, Amazon, or whatever, right? I mean, talk about us wanting to.
Right.
So all sorts of fun, right? So we hear this every day. So now, obviously, everybody's level of sophistication when you're dealing with your particular suppliers is going to be vastly different. So speaking to the generic everyday, if there's no contract, great. What's your purchase order? What are the terms? Have you thought about your Incoterms? If you don't know what an Incoterm is, get on it. We have awesome Incoterms 2020 guides. We have a Bloomberg Law article on the subject. Happy to share that. But it's a must. You need to know when risk of loss passes to you, when the supplier transfers his risk of loss to you. And if it's something you can negotiate, say, you know what, supplier, I don't want to take any liability. You ship it to me DDP. You'll be the importer supplier.
At a minimum, what I tell clients, at a minimum, you want to have the foreign producer have some skin in the game. And if it's a product that the foreign supplier says, hey, this is not going to be a problem, I'm cooperative and everything else, I look at him and say, great, we'll buy half of it from you delivered, we'll import half of it, and that way we're both on the line for duties, because the only person on the line for duties is not the foreign supplier, it's the importer of record. And the foreign supplier has no liability if they screw up. And so you want the foreign supplier to have dollars in the game. And the foreign supplier may say, but I don't want to be the only one with dollars in the game. Fine. Split it 50-50. I recommend that all the time.
I love it. And the big aspect, Andy and Lalo, to think about is who has the liability here. And you're going back to your importer of record and your reasonable care obligation. So going back to your tips and what an importer has to do, it's, look, everything in life involves risk. Without risk, there's no reward. I don't know anything in life that's risk-free and reward plenty. And if you know it, call me. I'm happy to talk. And yes, I buy lotto tickets. So look, at the end of the day, there's always risk, and commensurate with the risk is usually the reward. But my point always is open your freaking eyes and understand your risk. And if you don't understand what your risk is as an importer, I beg of you to read the reasonable care checklist. It's 10 pages online, and at least understand what you're liable for. And when it comes to anti-dumping, customs specific question, which I'll read from the guidance, is, have you taken measures or developed reliable procedures, not just procedures, reliable procedures, to check to see if your goods are covered and subject to a Commerce Department AD/CVD investigation, investigation or determination? And if so, have you complied or developed reasonable procedures to ensure compliance with customs reporting requirements upon entry? That's your type 3, Andy, right? So look, you've got to look at investigations, you've got to look at existing scope rulings, and you've got to look at the existing scope determinations, and you have to compare that to what your imported goods are. And if you don't have an expert that's doing it internally, you must have an expert that's doing that externally, because we've seen anything from pencils to candles to furniture to you name the gamut, to pasta, to all sorts of crazy things that are on that list that you would say, no, we don't care about that country. This is a war on China. It's not just a China war, okay? That's number one. It's not just China that's on our AD/CVD order list. There's a list of every country under the sun that's on that list, and products that you may never think of. So it's one of those, you wouldn't think of that. Like, who thinks of olives? Olives are good. Don't we love them? We don't have beef with olives. But, at the end of the day, crawfish, like crazy things are on these lists at times that you may not think
wouldn't
of.
it crawfish out of Vietnam or something?
At the end of the day,
black olives out of Spain, crawfish out of Vietnam.
Let me ask you this. Would bond companies be a resource for you to help in this? No.
I don't trust a bond company.
No, but they'll happily want more liability. I mean, they want more insurance from you.
I don't trust a bond company as far as I can throw.
Let's talk about this. David, don't do it. Don't do it. Don't do it. Cut that out. At the end of the day, the way this works, look, realistically, let's think about it, right? And go back to risk and reward, right? So every surety is going to receive a premium, and they're going to want to protect their own assets, just like everybody else does. Every business has their business and has their potential risk reward, right? And any insurance company is going to be freaked out if they see any potential items that may or may not be subject. But what they do, if you look, and I want every importer to think about this, when you're filling out your bond request, they're going to ask you if your goods are subject to AD/CVD. They're going to ask you about your ownership, and they're going to make your life a little more miserable.
So you got to get ahead of that ball
game
before you start going down that road then. Exactly.
But do you really think, Andy, that an insurance company is going to sit down with you and say, hey, let me teach you about anti-dumping, and let me show you, let me help you answer this question. Let me go over the scopes with you and your products so you answer this question correctly. Let's have a lesson on anti-dumping first.
As long as the bond amount is sent by customs and securitized by cash support, the bonding company doesn't give a damn. It's just not something that bonding companies have any financial incentive to care. Quite the contrary, bonding companies like product to be subject to dumping if you're going to pay the duty, because they hold on to these massive cash collateral, and they don't pay interest on it, and they get interest on it. It's great for the bond. Dumping duties are great for the bonding companies, because the bonding companies have no risk, and because they make everyone fully collateralize their bonds. The bonding companies have no risk and lots of benefits.
But let's talk about that. That's if the bonding companies realize that it was type 3 pre-entry. I mean, we've seen both sides of the coin there, where bonding companies are also screwed out of there, but 50K, like the usual bond amount, 50K. Granted, there could be millions owed, so they're out 50, but now 50 for how many bond periods? And your bond period is for that year. So then you have bond stacking issues and so on that go on. But I mean, the reality is, if a bond company is out any money, you better bet your butt that they're going to aggressively pursue whatever it is they're out. And they're a lot more aggressive in the pursuing of any money
Well,
that
and
they're out.
on the same token of that, though, let's say if it goes through and there is an assessment of anti-dumping duties due or CVDs, then the other scenario there is if that's not satisfied, then customs more than likely is going to be suspending your privilege of being able to import. Is that not correct?
So let's talk about how that works first. So the first thing that customs is going to do is they're going to go after your bond, and they're going to see whether or not, that can cover it and can't cover it. So if the IOR ignores CBP bills, then CBP has the right to go after your bond. You don't pay, your surety pays, then you have to pay your surety and work that out separate and apart. Customs doesn't care how you work with your surety or don't work with your surety. But now if you're not paying duties, period, customs can put you on the sanctions list and basically say anything you import, period, you're going to have to pay your duties up front, or I'm not giving you a CBP release because I don't trust you anymore. So that's what we see more often is you get on the bad guy sanctions list so that your imports must be paid a lot faster than, everybody else.
Right. This is great. I mean, this is great information. I mean, it's things you don't hear out there. I mean, you very bluntly, you both are saying, do you want to get into this or not? Assess the risk.
Well, and that's one of the things I think is that the importing into the U.S., I think that is a resource that definitely I think we need to see if we can provide the link for folks to use that and or order it from customs if they still print it.
The one point I would make, if we look at it historically, and we can date back hundreds of years, importing has always been a high-risk, high-reward obligation. That's why the coffee shop Lloyd's of London was created. Because literally, if you sent your ship out and it came back once, you broke even. Your ship came back twice, you were a London rich merchant. I mean, the risks and rewards of importing since the 1400s has always been incredibly significant, and we've lost sight of that in our current scenario because we no longer have the significant risk of cargo loss that we used to have, and now we've substituted the risk of government-sanctioned administrative loss for the old risk of my sailing vessel sailing off the edge of the world risk. So it's not a new risk for importers, it's a different risk for importers. And they must simply be aware that this is not a risk-free business.
At all. And it's know who your business partners are, know who your experts are, and know your risks/rewards. And as David said, you really have to evaluate them. And too many people get into importing with their eyes closed because they're so excited about the sale potential on Amazon. I know this is going to be a bestseller. And at the end of the day, we pray everything's a bestseller. And I hope people sell out and I hope everybody gets rich. But at the end of the day, there's not a lot of love or compassion at all from the government side if there was a lack of compliance at the front. Yeah. So I will say this. Yes. The last thing, Andy, is we have a top 10 tips cheat sheet that I always give a shout out to. So I'll happily share that with Lalo as well to share with any of your viewers who are interested. And I like cheat sheets, I like tips, and I like resources for especially those small businesses who I have a lot of love and compassion for, because I get the idea of being passionate and starting a business. I love it. I'm passionate and I started a business. Great. I can absolutely understand those particular sentiments, but I cannot understand starting a business without a business license, starting a business without registering, starting a business without protecting yourself in any way, shape, or form. This topic, anti-dumping, needs to be thought of in the same realm. This is one of the largest risks that a business will have that will absolutely put you out of business if you don't think about it at the onset of your business. Prior to purchasing a good, your sales/purchasing group cannot not think about anti-dumping. This needs to be at the forefront with all of your other compliance topics. This needs to be the same place as we're marking, valuation, country of origin, HTS, and so wherever you think of whatever I'm going to sell this price to for my final customer, put this on your cheat sheet of If I don't have this cost, I cannot determine what
And
cost
the
I'm going to
purchasing
sell my
folks
product
that
for.
are sourcing the goods cannot just look at it purely at the cost of those goods, the manufacturing cost of the goods. They have to look at it holistically, and that's where, generally speaking, I have seen where the purchasing, sourcing folks are not in sync with the compliance and vice versa. And that is probably right there is one of the most crucial things that a senior executive could bridge that gap and say, you two need to share your goals and your objectives and your bonuses together, because that's where it's going to come into play. Because if one does something and they find a good source, but then the anti-dumping liability there is ridiculous, there you go. So, and I look at the case on light truck tires. Oh my gosh. I mean, that was one where people were getting tires in here, dirt cheap for all these. And me being in the South, everybody has a truck, right? And next thing you know, there was a lot of businesses that were suffering because they were trying to get these cheap tires in, and now all of a sudden they've got a whole nother situation on their hands. So. All right, listen, we need to wrap this up. I thank you so much. You guys, man, you will forget more than I'm going to get to learn. So this has been fantastic. I greatly appreciate it. We're going to have more because we need to do more shows on this and see if we can't help people, again, get ahead of the ball game and go for that. You guys have both been absolutely fantastic.
Jen, David, what I was going to say is, Jen, David, we'll use links to your documents, to your resources and all that. Everybody's going to have access to that if you have it publicly there. Yeah, we'll do that. We'll do that. So thank you both. I mean, Andy, this is great.
Thank you. Thanks for having us.
Well, we're going to have you again. Promise.
All right. Thank you much.
Anytime.
Thank you all.
Take care, guys.
Thank you very much for joining us. Simply Trade is brought to you by the generous contributions of Global Training Center. You can follow the show and GTC on LinkedIn or Twitter and other social networks. Make sure you check out the show notes in the description for a full rundown of today's show with all the important links. Also, make sure you share this with a friend and subscribe on your favorite streaming platform. We really like hearing from you. If you enjoyed the show, make sure to rate and review wherever you listen to this podcast. If you or someone you know would like to be a guest in the show or would like to sponsor Simply Trade or suggest any topic you would like for us to discuss, please contact us via email at simplytrade@globaltrainingcenter.com, or you can DM us on Twitter at simplytradepod. Thank you again for the privilege of your time. Happy trading. Simply Trade is not a law firm or an advisor. The topics and discussions conducted by Simply Trade hosts and guests should not be considered and is not intended to substitute legal advice. You should seek appropriate counsel for your own situations. These conversations and information are directed towards listeners in the United States for informational, educational, and entertainment purposes only and should not be substituted for legal advice. No listener or viewer of this podcast should act or refrain from acting on the basis of information on this podcast without first seeking legal advice from counsel. Information on this podcast may not be up to date depending on the time of publishing and the time of viewership. The content of this posting is provided as is. No representations are made that the content is error-free. The views expressed in or through this podcast are those of the individual speakers, not those of their respective employers or Global Training Center as a whole. All liability with respect to actions taken or not taken based on the contents of this podcast are hereby expressly disclaimed.